Hello there. This is video number 2. Okay, in this video I'm going to talk briefly about the scope of discovery. Again, you should watch this series of videos in order, and you should watch them after doing the relevant work that's in the assignment. All right, now I'm moving to the discovery study questions, and we're going to see that 26b1 is the heart of the discovery rules. Okay, for anything to be discoverable, it's got to fall within the scope of discovery under Rule 26b1. So that's our very first question. What is the scope of discovery under Rule 26b1? Let's turn to this. We're going to see that each and every one of these words matters. Okay, parties may obtain, they don't have to, but they may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. Okay, let's start there. For something to be discoverable, it's got to be relevant to any party's claim or defense. So P versus D for negligence, and D's answer says plaintiff was contributorily negligent, right? Well, plaintiff can get discovery from the defendant regarding the negligence claim. Plaintiff can get discovery from the defendant regarding the contributory negligence defense, and the defendant can get information from the plaintiff on those matters too. Okay, and in fact, under certain rules like depositions, plaintiff and defendant can also get information from third parties, such as witnesses, such as people with relevant documents or other information that would otherwise be relevant to any claim or defense. Okay, so anything that's relevant to any claim or defense, but it's also got to be non-privileged. Okay, something that's non-privileged. And we're going to talk about privileges in a future video, but privileges would include things like the attorney-client privilege, include the spousal privilege, it would include the priest-parishioner privilege. It could include, if there's a relevant psychoanalyst or psychiatrist privilege. Also, the Fifth Amendment constitutional privilege against incriminating yourself. Okay, so if something is a privilege and that privilege is still in effect, it's not waived, then that matter can't be discovered even if it's relevant. Okay, so discovery can only be of non-privileged matter. We're also going to find out there's things that are somewhat similar to privileges but are not privileged, which would be work product protection. That's going to be both under the Hickman case, which you've been assigned, as well as FRCP 26B3. And that deals with the work product of attorneys or sometimes other persons that are prepared in anticipation of litigation, and those have protections as well, though not as strong as privileges. We'll talk about all of that in a little bit. So our starting point is something's got to be relevant to a claim or defense, and it's not privileged. Well, let's think about, what is relevant. Well, relevance is sometimes also used interchangeably with the word material, and you might recall the word material from FRCP 56, and the standard for summary judgment is that summary judgment is appropriate when there is no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. Well, material and relevant essentially mean the same thing. This is something you're going to discuss more in greater detail in your evidence course, but it bears brief mention here. Information is relevant if it makes something that's legally important to a claim or defense more or less likely, right? Suppose plaintiff sues defendant for negligence, okay? And the plaintiff's complaint alleges that D was drunk, okay? Well, suppose the plaintiff is deposing a witness who may have seen the defendant drinking at a bar, okay, 2 hours before the accident. Well, that would be relevant information, wouldn't it? If the witness is able to testify the defendant was drinking 2 hours before the accident, then that's evidence that may make it more likely the defendant was in fact drunk at the time of the accident and therefore more likely to be negligent. Now suppose that's witness 1. Suppose witness 2 was being asked if a defendant was cheating on the spouse. Okay, defendant cheating on D's spouse. All right. Well, it's hard to see how the information from witness 2 is relevant or material to the claim at all, because if plaintiff sues defendant for negligence, then testimony as to whether the defendant was cheating on his or her spouse doesn't seem pertinent to showing that it's more or less likely that the defendant was drunk or otherwise negligent at the time of the accident. Okay, so relevant information is not just any information. Relevant information is information that is relevant to the claims, the defenses, right? They make the claims or defenses or elements or parts of them more or less likely, or for some other reason, right? Such as impeaching a witness, like showing that they do not have a propensity for being truthful. Okay, so again, information has to be non-privileged, and it's got to be relevant. Relevant to what? A claim or defense. Now, let me briefly comment on the phrase relevant to any party's claim or defense. That's interesting, because what we see here is what's called discovery as a matter of right. Generally speaking, stuff that's relevant to a claim or defense is obtainable as a matter of right, subject to some limitations. Prior to 2015, there was language in there that also said that you could broaden the scope of discovery upon court order if it was relevant to the case. Okay, so under the old rule, claim or defense, something relevant to a claim of defense, then it says of right. Okay, and then there was this hazy area out here that was relevant to the subject matter of the action. Okay, and then you just had to ask the court. Now, empirically, I don't know how often that was used, but in 2015, they got rid of this basis here, saying that it was not really used all that much, and therefore they got rid of that. So now the scope of discovery is just what's relevant to a claim or defense. And when you think about it, that makes it all the important under Rule 8A and 8B and 8C to be careful about what you're pleading in terms of your claims, counterclaims and cross claims, third-party claims, right? As well as in your defenses. Because what you or your opponent are entitled to for discovery depends on all that stuff you say in 8A and particularly 8C, I suppose, as well as to some extent Rule 12B, any of those defenses. Anything that's in any of the claims or defenses then becomes fodder for discovery, because if somebody wants to seek something that's relevant to those claims or defenses, then they can and they likely are going to ask for that. So, if there's stuff you don't want people to ask about, then don't plead it, because you've now made it an issue in the case. Now, here's a couple other things about the scope of discovery. Now, I'm going to jump for a moment over the proportionality requirement. Okay, we're going to come back to that. That's something we'll save for the end. Instead, I'm going to focus on this last sentence for a moment. Information within the scope of discovery need not be admissible in order to be discoverable. This language has been changed a little bit since 2015, but not in any major way, at least in my opinion. Okay, what's this saying is you can get discovery on stuff even if that information is not itself admissible in evidence at trial or admissible for purposes of summary judgment. And we've already seen that in the scope of Rule 56. Okay, you remember under Rule 56, something is can be considered for summary judgment so long as it's admissible in evidence, or so long as it can be reduced into a form that would be admissible at trial. Well, again, what does all that mean? Well, here I'd ask you to think about this, about hearsay. So suppose P sues D for negligence, and P calls witness number 1, and witness number 1 says, Bob told me D was drunk at the time of the accident. Okay? Well, Bob told me D was drunk is a classic example of what's likely to be hearsay. Hearsay is an out-of-court statement that's offered for the truth of the matter asserted. In other words, it's something that somebody else said, somebody besides witness one said, and the only reason it could be relevant is because we're using what witness one said to prove the truth of the underlying statement, which was D was drunk, right? Well, D was drunk is hearsay because witness one wasn't the one that has personal knowledge. If anyone has it, it might be Bob, right? Well, this statement here probably wouldn't be admissible at trial. It's probably hearsay. Now, when you get to your evidence course, you'll find out that there's all sorts of bases for excusing hearsay and allowing it to be admitted. And there's other times when hearsay isn't hearsay and is considered non-hearsay and thus admissible, such as a party's statement against their own self-interest, right? Well, you'll talk about that in your evidence course. But what I'm getting at here is unless there's some reason to allow it to be admitted, what witness one has to say couldn't be used at trial. So you can imagine that D at the deposition would object. Objection, hearsay. Don't pay attention to what witness one said. It can't be used. But that doesn't matter because information can be discoverable even if it's not admissible at trial. Why? Because witness one's statement could be used to let P and D know to depose witness two, who is Bob. So this non-admissible statement might lead to an admissible statement by Bob, who says, I saw D was drunk. Okay? So, witness one's statement can be used in discovery, and it would eventually then lead to a deposition of Bob, who might be able to say things that could become admissible in trial. Okay, so now I'm sure you understand that part. Let's spend the last few minutes of this video talking briefly about this middle statement. And this middle statement is odd. This middle statement is odd. Rule 26b1. This part here is the proportionality requirement. Even if something is non-privileged, and even if something is relevant to a claim or defense, it's still not discoverable if that information is not proportional to the needs of the case. So the scope of discovery itself looks not just the relevance and non-privileged matter of the information, but also to the proportionality of that information to the needs of the case. And what's weird about this is most of this stuff here used to be in other parts of Rule 26b, and the rule makers in 2015 thought it important to shift that from elsewhere in the rule and put it up into the heart of 26b1, because 26b1 is the most important part of the discovery rules. It goes to the heart of discovery because it tells you what is and isn't discoverable. So in one sense, what they're trying to do is remind you of the importance of the proportionality requirement. But by moving it to 26b1 and even adding some language here, the new language here that's been moved and revised kind of invites parties, typically defendants, to file motions to not respond to discovery, or simply to refuse to respond to discovery requests based on a supposed lack of proportionality, because all of these things are very standardish, aren't they? Oftentimes very debatable. We consider the proportionality in light of the importance to the issue at stake in the action. Well, that's often going to be debatable. Mountain controversy. That maybe makes a little sense. A cheap case maybe doesn't require as much discovery, but on the other hand, sometimes people sue not because they want money, because they want some sort of vindication in court. And should a party or opposing party or a judge be measuring whether or not vindication or truth finding is required or not, just because not a lot of money is at stake, right? Sometimes important societal rights are litigated for even nominal damages, but that doesn't mean the underlying rights lack social value. Other things, the party's relative access to information, right? Their resources. So does that suggest rich defendants should be subject to more discovery? Poor defendants should not, you tell me. How central the discovery is to resolving the issue, whether the burden or expense outweighs its likely benefit. In my opinion, and in the opinion of a fair number of scholars, this language here is the Supreme Court's way of inviting litigants, typically defendants, to either oppose discovery or fight discovery to try to lower the cost of discovery and maybe increase the likelihood of gatekeeping and getting rid of cases early. And it's just another example, I think, of how social policies can be enhanced or frustrated through procedure. So procedure is not just this bland thing that doesn't matter to the real world. It actually matters quite a lot. You know, if you were Mr. Iqbal, I'm sure you would agree that procedure matters in whether or not you're able to vindicate your rights. So let me look up real quick. I think that's pretty much it for this video. We looked at the scope of discovery. Yes. We looked at admissible. We looked at the proportionality requirement. Okay, good. So, guys, that's it for this video. Let's end this, and we'll pick up with the next video. Thank you.